You know, I think we're really starting to see Lori Vallow's true side because Lori Vallow's the type of person who wants to portray herself as someone who is pleasant, happy, giddy. You know, she's like a gregarious person who is just like such a happy person all the time. However, Lori Vallow, I think similarly to Sarah Boone, when she doesn't get what she wants, you start seeing the true person. You start seeing the frustration, you see the accusations that she's making, and things are getting really heated between her and the judge. And initially, when I made the title of this YouTube stream, I was like, Judge looks fed up with Lori Vallow. But as the stream was, as the live stream or the hearing was happening, I was like, oh, no, no, no. I think the judge is like really fed up with Lori Vallow. Like they are trying so hard to be very accommodating to her because Lori Vallow still doesn't know what the fuck she's doing. So we are now in another trial for Lori Vallow. Yes, Lori Vallow is heading to another trial. This is going to be her third one. The first one is for the murders of her two children and Tammy Daybell. And then recently we had the trial for the murder of Charles Vallow, her husband. And now we have the attempted murder of her niece's husband, Brandon Boudreaux. Now, I want to cover the hearing that happens today. It gets really spicy. And oh my goodness, like Lori Vallow is just like, she's starting to get unhinged, man, because this is what happens. When you are someone who doesn't get what you want, you start getting frustrated. You start, your true self just starts leaking out. It's hard to have that disguise anymore. That mask just like falls right off. So we're going to cover that. And then we want to jump over to the Charles Vallow trial because again she was found guilty for the murder of Charles Vallow. Now it wasn't her who did it, it was Alex Cox, but she was the one who was involved in the conspiracy to murder him. So she wants to have a new trial. Now she's going to say things like, oh, there was like jury was like, doing things that were improper. They were looking up my previous what's it called history, and that she was accusing the judge of being biased. And so we're going to read all of that, and then we're going to read the state's response to that. Whew. It's gonna be a pretty wild day, y'all. Hi Taxi, how are you doing today? Hello Dunn, never been this early, heart. Hey Alexis, hello. I'll be so happy when she goes away. Yeah, I think after the June trial it might be the end of Lori and she'll just fuck right off. I'm so surprised that she wants to represent herself because, oh my God, did she fumble so hard in the Charles Vallow trial? However, I wonder if she thought she did a good job. I wonder if she's like, you know what? I did such a good job out there. Everyone's just against me. The judge is biased. The state prosecutor, well, she's a see you next Tuesday, because, I think Lori Vallow, I think she really does not like Trina K. Trina K went up there and demolished her. But Lori Vallow seems like the type of person who wouldn't admit that maybe she's not really a great person to really be representing herself. Anyways, so we're going to jump over to the hearing that happened today. Again, it's a pre-trial hearing for the attempted murder of Brandon Boudreaux, her niece's husband at the time. And then we are going to jump over to Lori Vallow requesting for a new trial and then the state's response to that. Oh, man. Lori's already going to rot in jail. She just wants attention. I mean, honestly, like we keep saying this, she just wants, it's like busy work. It gives her something to do, right? Rather than just sitting there and just not doing shit, I guess. But this is the only excitement that she'll have in her sentence, I'm assuming. Now, we'll see what happens, because she did ask for a new trial. We'll see what happens, and she'll probably go to, try to appeal it once the judge denies it. So let's hop on over to Miss Lori Vallow. And the hearing wasn't too long today. It was quite short. But man, things were getting pretty fucking heated. And you can tell the judge is trying so hard to keep calm, to keep cool. Hey, Tabby, how are you doing today? I think she just wants the attention. And since she's already in prison, she probably thinks, what does she have to lose? Yeah, exactly. Hello, Kelsey. How are you doing today? Hello. Honestly, I think no matter how she does or what she does, she thinks she did a good job. She's so full of herself. Yeah, I'm starting to get that. It's the delusion. Yeah, exactly, Taxi. She wants to be extolled as the goddess that she is. And I wouldn't surprise if she has that self-confidence, but then that self-confidence can really turn into something as like, just being really cocky. Hey, Kendall Dad, how are you doing today? Thanks for joining us. Hello. Yeah, even if it's for a short time, I appreciate you popping in and being here. Done Breezy, Lou. Alrighty, y'all, let's just hop in. Let me make sure I have my captions on and let's pop in.
For the record, I believe the victim is appearing virtually.
Lori Daybell.
All right.
I'm going to boost the audio up a little bit.
We have a number of things to discuss and get through here today.
Do I have to slow down for some reason? Oh, I do. I forgot. I was trying to I was like, why are we going so slow? All right, y'all. I'll be adjusting the audio and I'm going to have it normal speed.
Okay, first of all, is the motion for new trial. The defendant filed.
Why is this so low? Give me a second. Let's see. This is this. Let me see if I can boost it up. Am I in the right browser? Volume master. All right. Omega boost. By the way, Lori Vallow is going to be deep throating her microphone. Okay. I don't know why she's like all up in the microphone, but just bear with me. Whenever she starts talking, the microphone is going to be really, really, really bad. So what needs to take that microphone and just back it away just a little bit.
Filed. I received the response. I think the reply is due today. Is that being filed?
Yes, Your Honor, I have it right here, and
Is it ready to be filed?
yes,
Okay, we'll file that. You have a copy for the state?
I do.
Okay. The response, I'll take a look, or the reply, I should say, I'll take a look at that.
Do you think this is a trial? This trial is a way to get any other family members indicated, like the niece or her mother? I mean, she could have tried to call more witnesses in the murder of Charles Vallow, and she didn't. So I think if she wanted to try to pull something like that, maybe she would have called them when she was presenting her case. So remember, when the state rests their case, we're like hoping Lori Vallow would testify or she would call some witnesses, even though she seemed to not know what the fuck she was doing with the subpoenas. I don't know what she's doing. I don't even know if she knows what she's doing, but she seems like a very confident person. Oh, Alexis, you'll see what I mean. You'll see what I mean. I'm not even exaggerating here, okay? I'm not even exaggerating.
The next thing I wanted to discuss was the state had filed a notice of its intent to use defendants' other acts to establish conspiracy, premeditation, and/or establish motive pursuant to Rule 404B. In your pretrial statement, you indicated you wish to strike or withdraw that?
Correct, Your Honor.
Okay, so that's withdrawn. Next, we have state's request to preclude the media from showing the face of a testifying witness, one of the witnesses. I'm assuming you don't really have a dog in that fight, Ms. Daybell? Or do you have a response?
I don't have a dog in the fight, but I haven't had a chance to read over. I just got a bunch of this stuff, so
Did you really just get a bunch of this stuff, or have you had it for a little bit and you just didn't really read it? I don't know if I really believe Lori anymore, because Lori has made some accusations at the state. For example, do you remember mid-trial, there was a time where I think Lori Vallow is like investigator or someone like that on her team, had issues with opening some sort of like Cellbrite file, something like that. And Lori Vallow tried to say that, like, oh, the state dumped like all this like cell phone evidence mid-trial. But then when we looked at the state's response, the state was like, no, she's had it for about like, I think a year now or something like that. They just didn't really get into it. So when Lori Vallow says things like, oh, I just got it, I don't know if I believe her, because Lori Vallow is, she's not trustworthy, She's not trustworthy.
I'm not really sure what they're asking for.
Well, one of the witnesses also works in an undercover capacity, and showing that witness's face could compromise other investigations or things that witness is doing. So it's a request to not broadcast his face through the media out into the...
I don't have the motion on me because it was on a Facebook post, and I usually don't like showing Facebook on streams, but now, I think the agent that you're talking about is Agent Nicholas Balance. And if that name rings a bell, then you guys might be following the Idaho 4 murders case as well. I think it's the same agent. Nicholas Balance was also an agent, same name, on the Koberger case. And remember, they were doing the cell site tower analyzation thing. And then Koberger's defense expert was saying that, like, oh, this guy, like, we don't know how he put his data together. There might be some evidence that he precluded that could be exculpatory to Brian Koberger. And there was like a whole like shitstorm. And basically, yeah, I think it's the same guy. Because the same name, Nicholas Balance, works at FBI, does like the CAST system and the cell stuff. So I think it's the same agent. And I was really excited to possibly hear this guy's testimony, because remember, the defense threw some accusations at Nicholas Balance. And now I kind of want to know, are we going to find this guy credible? And, we could see him testifying in this trial, just to get like a feel for him. So when I read the motion for this case for Lori Vallow's, apparently this FBI agent is going to testify about, maybe like cell site locations of some of the victims or maybe like some of the people involved in this case. However, because they might be involved in some undercover work for the FBI, they don't want to broadcast their face to the entire world. So that's what they're talking about with this motion. And then they're like, hey, the state wants to make sure that this person's not going to have his like face live stream. Lori Vallow, are you okay with that? And Lori's like, I don't know. I just got it. I don't know what's going on here. I don't know. I have no dog in this case.
Public. It also works in an undercover capacity, and showing that witness's face could compromise other investigations or things that witness is doing. So it's a request to not broadcast his face through the media out into the public.
And is this witness FBI or something to that effect?
It's Nicholas Balance. I think he is an FBI agent.
Correct, he is an FBI agent.
And he's a relevant witness because of why?
According to the state's notice, he created a PowerPoint regarding some of the Wi-Fi or cellular data
Cellular
location.
and Wi-Fi use, yes.
Yeah.
I have no real objection to him being obscured. I don't know how they'll do it, but
All right, so I'll direct the media during trial when witness Nicholas Balance
We'll just throw a paper bag over his face. It'll be fine.
is called to testify. They can't broadcast his face out. They can focus the lower part of the witness stand or something like that, but his likeness or image or face should not be broadcast out to the public. So I'm essentially granting the state's request in that regard. Next, we have state's amended request.
Ooh, I like Trina K's privacy monitor. You see that? You don't see anything on her screen. You see that little chrome reflection.
In that regard. Next, we have state's amended request for Rule 609 hearing and the defendant's response. When I read the amended request, you're simply adding the most recent conviction, correct?
Yeah.
You didn't really respond to that in your reply. You kind of just talked about the previous reply that you had made about, did you notice that she had asked to basically add your most recent conviction?
AKA the judge is saying, so Lori, it seems like you didn't know what the fuck you were doing. Did you just not see it? Like what happened here, ma'am?
saw that, but I didn't know what the law was since I wasn't sentenced for that yet, so I wasn't quite sure where to go on that, so I left it off.
Okay, with the 609, I think similar to the last trial, I'll put that off, and depending on if you testify or not, it only really becomes relevant if you decide to testify. So we'll table that for the time being.
Let's see. 609, Arizona. Oh, Rule 609, impeachment by evidence of a criminal conviction.
Next, I have the state's motion limiting to preclude inadmissible evidence relating to Tammy Latchik, who is a evidence scene technician type person from the, I think it's city of Chandler.
Gilbert.
Gilbert. Did you have a chance to review that?
I just got it, and I am in the middle of responding to that. But I do have a request in that regard
Which is?
from the state. Since it was, just given to us, and I'm sure that the state had that information clearly before now, we need additional information, and due to that late disclosure, I was going to ask the state if they could disclose to us the employment records of Tammy and the emails regarding this incident and any recordings or body cam videos so that we don't have to have my investigator try to do an investigation so quickly. If they have that information, if it could be turned over to the defense so that we don't have to try to gather that information so quickly.
Well, I don't think you're necessarily entitled to all those things if
I think I saw a glimpse of her makeup. Is that pink I see there? She got a little bit of pink there?
it's deemed that incident is irrelevant to her testimony. So I think the threshold issue is if you want to file a response where you think that is relevant, something that you can get into, an incident that happened 4 years later, I guess when can you file your response?
Without any further information, I don't know, when is that response necessarily due, Your Honor?
It was filed May 3rd, so technically it's already past due. So can you file it by next, you have a copy of it now,
I just got a copy, correct.
right? How about next Wednesday, the 21st?
Yes, I can do that.
All right, so we'll
And
set
I have
that
a
aside.
Wait, it was filed May 3rd, but she just got a copy? Just got a copy?
Question on that. Yes, I can do that.
All right, so we'll set
And I have
that
a
aside.
question on that as well. Can I make an objection on the sealing? Can I ask under what law or rule or statute that this motion was sealed under?
They've requested to file it under seal because of the nature of the motion and the contents of what that incident is, not needing to necessarily be in the public eye. So if you want to include in your motion an objection to it being filed under seal, you can do that as well.
Okay.
So you'll file that no later than May 21st. I don't need a reply on that. I'll deal with that, I guess, probably our first day of trial or so.
So you're not going to set a 609 hearing?
This is not a,
Oh, not the 609, but a hearing for Tammy Lachik?
I can listen to oral argument when you filed your reply, but I don't believe I needed any sort of hearing on it. So I'll deal with that May 29th or 30th, I suppose.
I mean, I get it. You know, you're pro se. It probably takes a bit. There's a delay because you're being incarcerated, get documents over to you. But damn, like 6 weeks to get the documents over? Maybe something happened.
All right, then we have the defendant's motion for no restraints in trial dated May 6th.
Oh, yeah, no restraint. So during trial, we found out, I think like midway, that she had the belt thing. Essentially, if she were to try to do something, escape, or maybe attack someone, they would have the little shocker and she'll just get like jolted really quickly in the stomach area. She didn't have the shock shackles, but she had the belly shackles, I guess.
I don't know,
Belly
in your
shock shackles.
motion, I don't know where you get the idea that the sheriff's office recommendation ever was that you have no restraints at all. Their minimum
Why would they ever recommend? Yeah, just let her raw dog it. She don't need a restraints or anything like that. Yeah, right. Sheriff's office.
recommendation ever was that you have no restraints at all. Their minimum recommendation was that you wear a rack belt.
Well, I have it right here, and I copied it verbatim.
Yeah, you
Okay,
said, what it said was, my recommended minimum requirements as listed above, and those were to wear a rack belt.
It said, or the recommendation of MCSO was that they could have a unarmed detention officer and an armed deputy sheriff if I was to not have any restraints.
Right, but that wasn't their recommendation.
Response, Lori?
I've received, the defendant's motion, I've received non-party Maricopa County Sheriff Jerry Sheridan's response.
On the MCSO security justifications, my understanding is that was his recommendation.
Your Honor, Joseph V. Hill for the Sheriff's Office, if you have any questions.
Oh, okay. Well, I'll deny the motion from the defendant. The same conditions will be set that we had in the first trial, that being you wear the rack belt, no leg brace. There was one incident during the trial where you asked to take a break because a strap was hanging down behind your jacket.
Did y'all see that? A strap hanging down? I don't know if I saw that. I probably wasn't paying attention. I was probably too blinded by her stupidity. No, okay, let me not be too mean.
We did that. We rectified the
myself.
situation. There's been no indication whatsoever that the jury noticed the rack belt or anything like that. So I think those conditions are appropriate and will remain for the second trial.
Your Honor, the jury was not polled to see if they noticed anything either. Was that correct?
Right? There was no request for that.
Oh gosh.
All right.
So the judge, I love it how like the judge is like so like over her. When what I noticed during the trial was whenever he made a ruling or if he had to address her, he would kind of just like look through her, not really make eye contact with her. Oh man, and similar to right now, he's like, "Yep, and you didn't poll for it. Yep, you didn't request for it. Whose fault is that? Who's representing themselves?"
So next we have
Oh, Lori, Lori, Lori. Who's she smiling at over there?
defendant's motion
Lori is like, "It's not me. I'm not the one who's incompetent. It's these people. They're just against me. They're biased against me."
to consult with advisory council and team during trial dated May 6th. I don't know, I guess, what exactly are you requesting? Are you requesting that during the lunch recesses, you be housed somewhere where you can meet with your team?
Correct.
Okay.
And I know that it's a, it's a DO situation, and I know that our DO has his other obligations to do, so I didn't know if another officer could maybe, if something could be arranged so that I would have time with my team during those breaks and during lunchtime.
Hey, Muhe, how are you doing today? Hi, Corky. This is a good break from Karen Reed and Diddy trials. Yo, in my Discord, we are just wondering what the fuck is up with the Diddy sketches. Even my brother, who doesn't follow true crime stuff, like DM'd me and was like, "What's up with this Diddy sketch?" I'm like, "Bro, I have no idea, but these sketches are fucking hilarious." And then for the Karen Reed stuff, yeah, I got up to the Karen Reed up to the lunch break, and then when I was getting ready, I was like, "Oh yeah, I forgot Lori Vallow got her pretrial stuff today."
We did accommodate that during breaks and recesses during the trial, to the extent that it doesn't delay the jury getting into the courtroom and resuming the trial when we need to, like when we take the 15-minute afternoon recess. That will continue. You'll have an opportunity to meet with them briefly. Over the lunch hour, I think is the real question. I did receive a response this morning from the sheriff's office, which indicates they don't really have an objection to that. Is that correct?
That's correct, Your Honor. There is an area on the fourth floor in the South Court Tower where she can be taken to meet with her advisory council, and they'll work that out.
All right. I don't have a problem with that. So if you need to meet with them when we break for lunch, just indicate to the DO that's what you need to do. There may be a day where you don't need to meet with them, but I'll essentially grant. Ms. Kay, I don't assume you have an issue with that.
I have no position on it.
So I'll grant the defendant's motion on that she can meet during the lunch hour. Again, the only restriction on that is that we're not going to delay bringing in the jury at 1:30. We'll expect everyone back in the courtroom to start on time. All right, let's talk about the trial schedule and the screening.
Ooh, yes. Okay, let's talk about the trial stuff really quickly. This is what I got yesterday from the Twitter. Shout out to Justin Love. Here's what we got. Or actually, maybe I should show that in the next portion. Actually, no, I'll let the judge talk. They'll probably talk about it, and then we'll get to it next portion.
I received in the state's pretrial statement. Have you seen that?
I just did, yes.
Your Honor, may I be
Yes,
excused?
go ahead. Thank you. The state's pretrial statement indicate there was some witness scheduling issues. If we get the jury sat on the 30th and impaneled on the 30th, the last Friday in May, and we have our opening statements and begin testimony and evidence Monday, June 2nd.
Wow, in 2 weeks.
You indicated that, the state indicated you would run out of witnesses either Wednesday or sometime Thursday.
Correct. That are available that week, yes.
Right, and then so we'll definitely go dark on Friday the 6th. I had initially indicated we would be in trial on that day, but if we
Yay, we'll have Friday off.
can't have any witnesses here, we'll be dark on that day, and we'll indicate that for screening purposes for the jurors.
So there's some witnesses that can't testify that week, but they can testify the week afterwards. And then one of the witnesses, like that I mentioned earlier, is federal agent Nicholas Balance, who I look forward to hearing their testimony because I believe it's the same person who's also going to be testifying in the Koberger case.
I think we'll still indicate that we'll be in trial on the 5th, and we'll have to play that by ear. Maybe we will be dark, maybe we won't. But as far as when you resume on the 9th, you said you thought you would have 3 witnesses left at that point?
Correct.
Do you have an anticipation? Are those witnesses that would each take a whole day, or?
I think it's possible I could finish that day.
So ultimately what I'm getting at is trying to drill down the schedule and screening for the jury. Do we not need to screen them for the week of the 23rd?
Obviously, I just received the defendant's 15.2 that lists 2 different expert witnesses. I did request that they actually comply with Rule 15.2 and give me any information about any of these experts. They've also listed other witnesses. So because of that, I would still screen them for the other week.
Well, maybe we should address that. Is there still no report from Lonnie Dworkin that the state's received?
I have received nothing.
Do you have some sort of expert report you were disclosing?
We will, Your Honor, yes.
When?
Well, when is that going to be? Because it's way past due.
So the state.
Hi, Diane. How are you doing today? Oh, man. Just like, the judge is like throwing a little bit of snark here and there, but it's not like unjustified snark. It's like, all right, so when are we going to get it? Because it's way past due, Lori. What's Lori going to say to this?
Past due.
So the state did receive the affidavit from Lonnie explaining the things, which is why they turned over late discovery in the middle of trial. So we did have that. He's working on a few things for us as well now, and I will get with him as soon as possible and get that report to you as soon as possible.
Not really an answer. Just as soon as possible. As soon as possible. I think the judge wants a date.
All right, well, it's depending on what's in that report, it is likely to be precluded at this point, but I'll keep an open mind on that, and it's
too
We'll
late.
wait and see. Let's talk about.
And who knows if it's even going to be relevant or not. Lori Vallow had issues with relevancy last trial as well. And she was like, it's relevant, Your Honor. It's relevant. Judge is like, okay, well, tell me why it's relevant. Well, it's relevant because it's relevant.
For the purposes of scheduling,
Your Honor, and just, there's one other person that I'm Googled.
I'm going to ask her about the other
Okay.
witnesses. I received your supplemental witness list, I think, yesterday. You have, in addition to Mr. Dworkin, you have Weaver, Barkman, again, Detective Moffat, Jeffrey White, Melanie Gibb, and
Oh, Melanie Gibb. I want to hear from Melanie Gibb. I don't think we've ever heard from Melanie Gibb before in any of the trials, have we? So Melanie Gibb is her niece, and apparently she was kind of like in the cult as well, maybe not as deeply involved as Lori Vallow, but I think she was like kind of like sort of involved. Now, remember, there was text messages between Lori Vallow and Melanie Gibb, and essentially Lori wanted to make sure that Melanie was around just in case they would have tried to ambush her and do a intervention.
and Zulema Pastañas.
And Zulema, I think it's pronounced Zulema. That's her brother or deceased brother's, I think, ex-wife. But they were married at the time. So Alexis Cox's wife. So it'd be interesting to hear from Melanie Gibbs and Zulema, because again, Melanie Gibbs' husband was the one where the attempted murder was on.
Zulema Pastañas.
Okay. Was Detective Moffat also involved in this case?
Oh, Melanie Gibb is the friend? Are there 2 Melanies? Am I getting it mixed up? Oh, hold on. Because Melanie Boudreau, sorry, I just assumed the Gibb was her maiden name, but then her maiden name would probably, because she was on which side? Melanie Gibb, mom's side. Oh, is Melanie Gibb the friend? I'm getting mixed up. Thank you. Hold on. Melanie Gibb. I'm going to do what Trina K did, and I'm just going to Google it. It seems like Trina K didn't know who some of these witnesses were. She's like, yeah, I Googled some of them. Lori Vallow. Let's see. Oh, that's Melanie Gibb. Okay, she's given interviews before. Lori Vallow Daybill's former best friend. Thank you. Okay. Thank you. Pawlowski. Okay. Pawlowski. Melanie Pulaski. Oh, okay. I had it mixed up. I thought Melanie Gibb was the yeah, I thought Gibb was her maiden name or something. Thank you, Muhair. Thanks, Sharon. I appreciate it. All right, guys. Erase what I said earlier about the Melanie. This is a different Melanie. This is Melanie Gibb, a former friend of, or a former best friend of Lori Vallow.
He was involved with the case agent of this case while he was the case agent of the other case. Correct.
Oh, okay. So I think he wants to ask Lori Vallow why some of these witnesses are relevant, and this is where we get into the funky relevant answers from Lori Vallow. So Detective Moffat, I believe, testified in the other trial with Charles Vallow. Lori wants to call Detective Moffat again, and the judge is like, "Is he involved in this case? Why are you calling him?"
It's Dennis.
Okay. Was Detective Moffat also involved in this case?
He was involved with the case agent of this case while he was the case agent of the other case. Correct.
Okay. So he may or may not have, he may have relevant information. Again, I guess that's a wait and see. What about, who's Weaver Barkman?
So he's a ballistics expert.
Is that an expert? So that's an expert. Do you have an expert report that's been disclosed?
Not yet, Your Honor.
Are we surprised? Are we surprised? 2 weeks before trial? Are we surprised?
We're working on it.
Your Honor, since I've not noticed a ballistics expert, that's a big problem, because if I get something, then I would have to do that. So the defendant's, again, extremely late violation of all rules of criminal procedure is a problem.
It is a problem. Who's Jeffrey White?
My investigator.
Oh, okay. And do you have an idea of in what capacity you think he would be called?
Well, we had made a request from the state for the car door and the window that the bullet supposedly hit, and we were going to have him inspect that as well. We have recently found out that those two
We were going to have him inspect that as well, meaning he hasn't even done it yet. I thought maybe he did it and the report just hasn't been generated yet.
things do not exist. So I'm not sure what they're going to be putting up as far as ballistics in their case in chief. So I was trying to have someone who could be able to look at whatever reports they're trying to put up and rebut anything that they're saying.
Is Mr. White an expert in that area?
Mr. Weaver?
No, I said Jeffrey White.
He's my investigator.
Right, that's who I was asking, who has relevant information. What's Mr. White's relevant information for, why might he be called as into trial?
Because he's interviewing the witnesses as well, the defense witnesses.
So is it some sort of extrinsic impeachment if they,
Correct.
Yeah, she's like, correct. It's like, girl, you didn't know the answer to that question. The judge was just helping you out here. He was throwing you a bone.
what about Melanie Gibb?
So Melanie Gibb and Zelina Pastinas were both initially noticed in the state's 15.1. They have not noticed them again. I don't know if they can still call them if they're on their list, but
Have you,
they have relevant information to this case.
have they been presented for an interview by the state?
They've both been interviewed multiple times by the state.
I mean, not by police officers, I mean by either a prosecutor or someone in her office for, in preparation for trial.
Any depositions, anything like that?
In this case,
Yeah, in either case,
not that I'm aware of.
have they been subpoenaed?
The subpoenas are out.
Lori's not flirting today because she knows it doesn't work with this judge. Kelsey, I said earlier that she's going to be deep throwing that fucking microphone.
What relevant information would they have?
They have relevant information to Brandon Boudreaux.
Okay.
I do feel bad though, because in trials or in hearings like this, I do wish there was a way for the person that's speaking to the microphone to hear how it feeds back in. Especially when there are witnesses that are testifying on the stand and they don't realize they're too close to it and they start breathing really hard into the microphone.
And around that
What
time,
is the nature of that relevant information?
All right, let me go back a little bit. So we're trying to figure out, why are these people relevant?
Not that I'm aware of.
Have they been subpoenaed?
The subpoenas are out.
What relevant information would they have?
They have relevant information to Brandon Boudreaux
Okay.
and around that
What
time.
is the nature of that relevant information?
Choose another answer.
It will come apparent if they have to get up and testify, Your Honor. I will only call them if I need
Well, they're going to
them.
be precluded if you can't give me some minimal, what relevant information they have. Just saying that they're relevant doesn't make them relevant. Okay?
Yes, and is this procedure that I have to say what each of my witnesses are relevant ahead of time and give my whole case in chief over to the state? It is?
Yeah, it's
That's
just
how
like-
it works?
like
That's
the-
the rules of law?
Stop interrupting me. Yes, that is the rule of law. That's just what the state does. They tell you what relevant information each witness has. So,
Went to law school versus didn't go to law school. Law school? No law school. Experience? No experience. Smart judge? Moron. I'm
My
being mean
answer's
today.
yes.
Oh, I'm going to tone it down.
so if you can't tell me what relevant information they have, they'll be precluded.
They both have had dealings with Brandon Boudreaux and Alex Cox. So
Okay, so does someone, that was a server for them at a restaurant. It doesn't make them have relevant information as to this case. Anyone who came into contact with Mr. Bedreau or Mr. Cox had some interaction with them at some point in their lifetime does not make them a relevant witness. So what is their relevance?
I was saving Rain's comment for this. Rain says they are relevant because they've eaten her green chili chicken enchiladas. True.
Or Mr. Cox had some interaction with them at some point in their lifetime does not make them a relevant witness. So what is their relevance?
the state had them on their witness list and they're saying they're not relevant?
Apparently not. Are you calling them?
No, they're not on my,
Police interview however many people they interview because they're working on the case. They don't know who has relevant information, who doesn't have relevant information. All the people that they interview don't end up being relevant. So because they're listed in a police report somewhere, doesn't necessarily make them relevant.
Okay, their relevance lies in if I have to rebut something that the state puts on in their case in chief. They're just called in case they need them. They're subpoenaed in case I need them.
All right. It sounds like they don't have relevant information. However, I'll include these names on the potential witness list for screening the jurors if the jurors have any knowledge of any of these witnesses out of an abundance of caution. That's really
When you get a non-answer, you got to answer it yourself and just move on. That's what the judge is doing.
the purposes for today is the questionnaire that goes out to the jurors. So I will include these witnesses. Again, Mr. Dworkin, Mr. Barkman, if they're expert witnesses that haven't provided any sort of report or expert witness testimony, they're likely to be precluded as witnesses. But I'll include them on the witness list. I think what I'm hearing is you said you might finish on the 9th or the 10th? I'm going to indicate on the questionnaire to the jurors, potential jurors, that the trial is likely to end by June 13th, Friday, June 13th. However, I'll include
Yay, short trial. Remember how the other trial they estimated to be 6 to 7 weeks because Lori Vallow barely did any cross-examination or even displayed any witnesses herself. It was just like, what was it, like 1 week, 10 days or something like that?
that Monday, the 23rd, and kind of say, if needed or if required, might go to June 23rd out of an abundance of caution.
Yeah, and spending your summertime in a courtroom.
So I'll finalize that questionnaire. It's pretty much done, and it's pretty much the same as the last one, except for the names of the witnesses, the specific allegations, and then I removed the question about viewing medical examiner autopsy type photos because that's not needed in this case. But I'll send you guys out a copy. Actually, I could probably finish it in the next couple minutes and print out a copy so you have it before you leave here today. That questionnaire, I need to get with the jury office. I think we were talking about sending it out the 22nd and cutting it off the 28th or 27th. And then we'll meet again on the 29th in this courtroom to go over the responses. That'll be at 1 p.m. on the 29th.
Your Honor, in light of the juror misconduct or the alleged juror misconduct, I have to object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
I was a little curious about this. I was like, oh, her personal life stuff, like in the jury questionnaire, what were they including? This definitely intrigued me.
What personal information?
The state versus Lori Daybell.
That's the name of the case.
That's why I was like, I can't take Lori serious anymore. I just can't take her seriously. I was like, oh my God, they included her personal information. Like, what was in it? That sounds kind of weird. Well, my name was on there. The state versus Lori Daybell.
You don't put that on anyone else's questionnaire or one other person that's ever had that questionnaire ever put out with their name on it. They just don't do it.
Do it in every trial I've done.
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep? Okay. How do we screen for if people have heard about you if we don't include your name?
She can't answer. Look at the judge's face. Okay, hold on a second. I need another. We did this for the trial. Do we have one here? I think we need like a zoom in for the judge, man. You gotta see the judge's face. The judge is like, I'm waiting for an answer, ma'am. Give me an answer. Oh my gosh, poor judge. Don't worry, judge. You just have just a couple more weeks of this, and you know, there will be some appeal stuff that you might have to deal with, but you know, you'll be done with Lori soon. You'll be done soon.
Done.
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep? Okay. How do we screen for if people have heard about you if we don't include your name? Do you have a response to that?
I'm just saying, you gave them your name, and they're just going to Google it.
They're instructed not to Google it, all right? And if you'll recall, when we had all the jurors come in person, one of the first questions I asked them in the afternoon was, who has looked up this case since you filled out the questionnaire? And we had 2 or 3 people raise their hand, and those people were excused. So I have to include your name to screen out for the people that know about your case. And we released about 100 jurors last time because of their answers to that.
That's true. Your Honor, if they Google me, they will find about the loin fire.
If we don't include your name, that's 100 extra jurors we have to go through in person and ask if they know you. And in fact, that increases the risk of tainting the rest of the jury pool if we have someone stand up and say, yeah, I know about her case in Idaho where blah, 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 in front of the rest of the jurors. That'll burn the whole panel. We'll have to start over. So I'm going to include your name in the questionnaire. I don't think there was any other personal information or background information about you in that questionnaire other than your name. So was there any other issues you had with the questionnaire?
I can't wait until we get the sidebars for the trials. The sidebars between Lori and the judge, we need to get the sidebars. Oh my goodness. If y'all thought the Sarah Boone's, oh shit. I forgot to post part 3 of the Sarah Boone sidebars. Oh, I'll post it today or later on today. But I want to read the sidebars between Lori Vallow and the judge. Oh my gosh.
No, Your Honor.
She gets so frustrated, but it's not like she even gave a good argument. Why are you getting frustrated? Your argument isn't good. You should know yours isn't good. I don't know. Maybe she doesn't know that her argument isn't good. Maybe she really thinks that she really has something here and that she was arguing, wholeheartedly. But most of the time when they're arguing, where she's arguing with the judge back and forth, a lot of it's just like silence, or she just repeats herself, or she just goes in circles. And then you get frustrated that you are losing these arguments, but you're not getting frustrated yourself. She's probably getting frustrated at other people, blaming other people.
So the schedule will be, we'll meet 1 p.m. to go over those answers on the 29th. On the 30th, we'll meet at 10. We'll have walk-in jurors that morning that will fill out the questionnaire. And then the people that survive are screening on the 29th, and those that survive the morning of the 30th will come in the afternoon of the 30th. This will be back in the courtroom we were in last time, 5D of the South Court Tower. Again, I expect to seat that jury at some point that afternoon. And then we'll plan on going Monday through Thursday, June 2nd to June 5th. Then June 9th to June 13th, and if need be, June 23rd.
Your Honor,
Yes.
I'd have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on the FTR several times during the trial.
Okay, well, I don't have any personal bias, all right?
You know what? It's not because I'm not making good arguments. It's got to be personal bias. It's got to be other things. It's not me. It's them.
I don't have any personal bias, all right? I've over-accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that, all right? So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not have merit?
Hold her to that. Hold her to that. Every single one of her motions has been denied. That's her claim. We'll hold her. We'll have her that argument.
Denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour.
Ooh, Lori, you just got destroyed. Lori, you just said every single motion. They're just like, well, what about the one this morning? I just granted your motion. Let's see if Lori responds to that.
Does not have merit. You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour. I have granted other motions of yours, okay?
That's the first motion that you've ever granted.
Well,
Oh, but you just said that he hasn't granted any motions the past year and a half.
On my behalf.
file motions that have a legal basis, and I might grant them.
So you're saying none of my motions have had merit.
Not
No, I guess they're just garbage, Lori. I'm sorry. I guess it's just, maybe you should just hire an attorney or something.
many, no.
And none of the motions that my first team, you denied every one of my first team's motions. You denied every one of my second team's motions. And now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied. Every single one of the second team's motions were denied, and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit, okay?
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law, all right? They filed a motion to have you dressed out, not in jail clothes during hearings like this, okay? That was not based in law. I denied that motion. So I've ruled on the motions as required by law.
Without any,
He's like, hey, I understand. You don't know what you're doing. And that's why you don't understand the process. That's why you don't understand the results. Oh, no, Chad would never deny my emotions.
I've ruled on the motions as required by law.
without any kind of a conclusion of law in them, just denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
You're telling me the judge has never said a case law? He just denies it. He just outright just denies it. I'm sorry, but Lori, you've already shown yourself as someone that exaggerates just to try to prove your point, and it ends up becoming moot because when your point is not proven and it actually becomes disproven, she just moves on and moves the goalposts. Okay, fine. Well, you granted that one motion. Okay, fine. You might have granted that one. Okay, well, you haven't granted any other ones.
Are you not going to recuse yourself?
No, I'm denying your motion. Anything else? All right, I was handed a
Quiet.
motion to suppress all evidence pertaining to Jeep Wrangler.
I have not received that.
Did
Jeep
you probably
Wrangler?
got a copy of it today or not?
Oh, is this the car that Brandon Boudreaux was driving or coming out of when he was shot at? I thought it was in a Prius for some reason.
No.
Oh, do we need to make copies?
Thought I heard Prius. Maybe not.
All right, go ahead and make copies for the state. I also have a motion to dismiss for non-preservation of crucial evidence. So make a copy. I guess the state can file their response to those.
You got a jury duty that would have been a 30-week trial. Kind of want to be picked because your work pays for jury duty. That's fucking awesome that they pay for jury duty. That's cool.
All right. Anything else for today from the state's perspective?
No, Your Honor.
From the defense?
No, Your Honor.
All right, we'll see everyone on the 29th at 1 p.m. Again, that's in this courtroom.
Oh, here's a smiling Lori. Nothing phases her.
Yeah. Thank you.
Oh gosh, Lori, 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 Lori. That chipper attitude is no more. Okay, we got more Lori stuff to cover. So for the Lori Vallow pretrial hearing, that was for the attempted murder on Brandon Boudreaux. Apparently he's going to be testifying, and yes, he is still alive. Yay! Unlike Lori Vallow's other victims, unfortunately. So they're going to have their trial in about 2 weeks. The trial is going to be roughly, I don't know, like 7 to 10 days long. And then possibly it might go into June 24th, depending on who knows what. We'll see what, maybe Lori's performance will be better this time around. Maybe she's learned. No, I don't think so. Because after that, just now, like Lori, I don't know why she's still representing herself. So here's a little breakdown of the Lori Vallow's trial that's coming up soon. Charges. We just what one charge. Count 1, conspiracy to commit first-degree murder, life with a possibility of release after 25 years. Although that won't really affect Lori Vallow at all. Settlement status. No offer has been made. Again, they're going to have 12 jurors plus 4 alternates. Here are the lists of the state's witnesses. We got people from the Gilbert Police Department. I don't recognize them. Chandler Police Department, Mesa Police Department, Phoenix Police Department, Department of Public Safety. We've got Rexburg Police Department, FBI. This is the name that I recognize, Nicholas Balance, although I think there's an L that's missing. If you guys are familiar with the Idaho 4 murder trials, Idaho 4 murders, that one has an expert with the same exact name who did the caste system stuff and the analyzation of it. So I think it might be the same guy. It'd be interesting to hear his testimony in this case, because the issue with the other case is that they're trying to say that the people that worked on kind of pinpointing Kohberger's location the night before the night of the murder, but like hours before the murders, during and afterwards, there were some information that could have been omitted, that could have been exculpatory to Brian Kohberger. So I do want to hear Nicholas Balance's testimony to see if he sounds like he might be a credible witness. We have DEA, we got civilians. I don't recognize a lot of these names, but maybe you guys do if you guys are familiar with this case. We have a Robert Anthony Abado Marco, Brandon Boudreaux, who is the victim, Elizabeth Jane Collins, Timothy Zane Deloach, Lynette Mendoza, and Dan Moss. I only recognize Brandon Boudreaux. Estimated trial day, 7 to 10 days. Here's a brief statement of the case to be read to the jury. The state alleges that in the days leading up to and including October 2nd, 2019. So at this point, Charles Vallow was already murdered. I believe Tylee and JJ were also already murdered. And same thing with Tammy Daybell as well. Charles Vallow again was in July, and then I believe JJ and Tylee. Do you guys remember? Was it in September? I think, right? September, possibly, maybe about 2 weeks apart. Lori Vallow Daybell and her brother, Alexander Cox, conspired to commit first-degree murder of Brandon Boudreaux. The state further alleges that Lori Vallow's co-conspirator, Alex Cox, drove a Jeep. Oh, the Jeep belonged to Lori. Got it. Okay. The Jeep belonged to Lori Vallow, but Alex Cox drove it from Rexburg, Idaho, to Gilbert, Arizona. The state alleges that on the morning of October 2nd, 2019, Alex Cox shot at Brandon Boudreaux from the Jeep as Brandon was returning to his house at 3875 East Fells Street in Gilbert, Arizona. Brandon Boudreaux was not injured. Trial schedule. The state has identified approximately 22 witnesses for this trial. 5 of these witnesses reside outside of Arizona. State has learned that 3 of the witnesses are not available to meet the week of the June 2nd to June 6th, 2025. Witnesses Timothy Deloach, Timothy Miller, Nicholas Ballens are not available to testify until Monday, June 9, 2025. The state believes that the case in chief will take approximately 4 to 5 days. The state believes that it will conclude with all the available witnesses either Wednesday, June 4th, or Thursday, June 5th. Yeah, the trial of Charles Vallow, the trial for Charles Vallow went by pretty quickly. They're just like boom, 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 get to the point. I freaking loved it. I like that speed. For these reasons, the state asked the court to go dark on Friday, June 6th, and potentially Thursday, June 5th. So these might be our days off. Resume on June 9th to call the remaining 3 state witnesses. Pending motions. Defendant's motion dismissed for abuse of discretion by Judge Boreski. That's Lori Vallow. State's amended 609 motion. State's motion in limine to preclude inadmissible evidence relating to Tammy they pronounced it earlier in court, but I don't remember it. Lachick. The state's request to preclude the media from showing the face of testifying witnesses. So that's what they addressed today in today's hearing. The state hereby moves to strike the state's notice of intent to use the defendant's other acts pursuant to Rule 404B. So that is what they covered today, and things were getting very fiery between Lori Vallow and the judge. Oh, man. So we will definitely be live streaming the trial when it happens in 2 weeks. Now, they're going to follow the same rules. It's not going to be live stream, like live. There is going to be a 30-minute delay, and you know what? I'll take that. I kind of like the 30-minute delay. And then we'll also refer to people who are going to be live tweeting from the courtroom. So Justin Lum, there was Nate Eaton, and there was another person, maybe Pretty Lies and Alibis, that was also tweeting here and there as well. So we'll take a look at their tweets, assuming if they all 3 will attend this trial. Now, we are also going to cover the previous trial. So Lori Vallow was found guilty for the attempted murder. For the murder of Charles Vallow. Again, she was charged as like a conspirator, as a co-conspirator, and she wants to have a new trial. So we have not read the response together yet. But before I read the state's response, I'm just going to go back and read Lori Vallow's motion that she filed for a new trial. And then the state has filed 2 responses since then, which we will go over. Someone asked me about the Diddy stuff. Anyone follow the Sean Combs stuff? I feel sorry for the baby of Cassie. It gets flooded with all the emotions her mom is going through. Oh, yeah, that's right. She is pregnant right now, right? The judge is a zombie too, denied her motions. Oh, man. I wouldn't be surprised if she was like, just like, there was a picture of Judge Boreski and she just wrote like Z, like all over it. Oh, man. All right. So, Lori Vallow's motion for a new trial. Oh, boy. Lori Vallow. Let's see. Chrome, window capture. Y'all ready for this? It's not too long. But, I haven't read through this yet. I've just read articles about it. Former hairdresser becomes mass murderer, becomes lawyer who thinks she can outsmart the judge. Motion, I lost. Can we have a redo? Gotta put in the baby voice too. But Your Honor, you deny all my motions for the evidence against me. How is that fair? The funny part is when she argues the relevancy thing, because I'm pretty sure the judge has schooled her many times about the relevancy. Like, just because you say it's relevant doesn't make it relevant. You got to explain why it's relevant. And then I remember last time too, when she was arguing with the judge, she was like, so you expect me to tell the state what I'm planning to use as my defense? It's like, yeah, we got to know what you're gonna, present, just like how Lori wants to have this ballistic expert to testify, but she hasn't even had them do the ballistic stuff yet or the report. And then the trial is going to happen in 2 weeks. Oh, man. Does anyone know how many months how many months pregnant she is? That must be tough, man. Lots of emotions running. Got to testify and you're pregnant. I can't imagine. Is she still testifying on the stand or are they already on the next witness? All right, y'all. So, Superior Court of the State of Arizona in for the County of Maricopa. Motion for a new trial. By the way, these court documents are not cheap. Usually when I request for court documents, it's like 35 cents a page, maybe. Sometimes you get really lucky and it's free for the public. But not in Maricopa County. You got to pay $10 per document. It doesn't matter how many pages, it's $10 flat. $10 fucking dollars per document. Oh, gosh. Anyway, so luckily one of these documents, I think it was this one I got for free off of Reddit, but the other two, man, $10. Honorable Justin Boreski. All right. Lori Dabo requests for the court to grant for a new trial. The motion is filed pursuant to the protections provided in Rule 24.1 of the Arizona Rules of Criminal Procedure, the Fifth Amendment Due Process Clause of the United States Constitution, and Article 2, subsection 4, and subsection 24, and, I think this one just means section, I think, of Arizona State Constitution. This motion is accompanied by the following memorandum of points and authorities. Memorandum of points and authorities. Facts. Dun dun. A. Juror misconduct. On April 28, 2025, it came to the attention of the defendant's advisory council and later the court that Juror 15 made a statement indicating he had knowledge of the defendant's prior conviction. We saw it together, actually, when they were doing the interview. There were like members of the jury that were leaving and then they sort of kind of got ambushed by the media. But I mean, they were willing to answer questions and stuff like that. So he also indicated that he was leaning towards not guilty vote until yesterday and through deliberations. This prior conviction involved the homicide of her children in Idaho in 2023. What? A homicide of her children? I thought it was a family tragedy. Oh. The defendant did not testify in the trial, and this conviction was not presented by the state as Rule 404B as other acts of evidence. Thus, Juror 15 should not have learned about this information. What a misrepresentation of what the jury said, or the juror said, because we listened to the interview together. Because this case was a high-profile matter, once a juror was released from the admonition, jurors were free to speak with the media. During an interview, Juror 15 was asked about his reaction upon learning about this defendant's prior convictions. He stated the following: I feel sorry for her. Driving home yesterday, I was like, God, she's spending the next 3 lives in jail. Oh, in prison, in a cell. ... B. Preclusion of Tylee, Ryan, and Alex Cox statements and an impermissible expert testimony by Detective Daniel Coons. Now, going back to the juror statement, I remember the juror said that when the trial was over, and that's when he decided to Google Lori Vallow, and then that's how he found out about Lori Vallow's prior conviction. It wasn't like he Googled it during, testimony or before deliberations or during deliberations. He said it was afterwards. B. The preclusion of Tylee, Ryan, and Alex Cox statements. All right. Prior to trial, the court precluded this defendant from presenting the jury any of Tylee, Ryan, or Alex Cox's statement. Both of these people were present during the shooting of Charles Vallow, and thus some of their statements were not hearsay as they show effect on listener pursuant to Arizona Rules of Evidence 803D, 803.3. 3 again. Okay. Now, we didn't hear the statements made by Tylee or Alex Cox. We didn't see their police interviews. And then also I remember when Tylee and Lori walked up to law enforcement, I think they muted that part of the body cam. Our assumption was that the reason why those statements didn't come in is because, well, Tylee and Alex, they are not alive anymore. They're no longer here to testify about any of this. The state filed a motion in limine throwing a blanket hearsay objection over the entire statements. The court indicated in the pretrial ruling that it would, at least Alex Cox's statements, take it on a statement-by-statement basis. During trial, this defendant was precluded from even discussing that Alex conducted a walkthrough, much less his statements with Chandler police detectives through that walkthrough. Then in the state's case in chief, it elicited expert testimony from the scene agent, Detective Daniel Coons. This defendant objected to his testimony as an expert witness based on the lack of foundation and her not having had time to rebut his professional opinion. Again, this defendant was precluded from discussing Alex Cox, the shooter, walkthrough that was conducted with several Chandler police detectives, including Detective Coons. This walkthrough was precluded as inadmissible hearsay. However, it formed the basis for Detective Coons questioning about the medical examiner and how he then investigated this case, as Alex Cox indicated he shot the victim in self-defense. Oh, this one, the discovery violation. April 14, 2025, during trial, Miss Trina K produced a hard drive containing the great key information for Charles Vallow's cell phone. The contents of the hard drive or exculpatory evidence. Defense has been requesting this evidence so she could provide it to her independent expert for his review. This discovery disclosure occurred during the middle of the trial. So I remember in the middle of the trial, after the jury was excused, I guess the investigator or whoever was working with Lori Vallow was trying to open the contents of the hard drive, and then Trina was like not having it. She was like trying to help, but also at the same time, it was like, per my last email attitude, did you not know this? Did you not read this? And they were having issues opening this document or whatever. We didn't really get any updates about that afterwards, so I assume maybe they ended up opening the documents and there was nothing on there that they wanted to present when Lori Vallow had witnesses that she could have called, maybe? I don't know. All right, prosecutorial misconduct. Oh, the good old PM. On April 8, 2025, the state elicited irrelevant, prejudicial, and improper character evidence when she asked Chandler Fire Captain Keller, if he overheard any conversations with the defendant. Oh man, this is so hilarious. This came out of left field. Apparently, he testified saying that Lori Vallow was complaining about not getting invited to a pool party because of all the commotions happening with her husband getting shot, I guess. Ms. Trina K asked Captain Keller in direct examination, did you overhear this defendant talking with the police? He responded in an affirmative statement. He stated he overheard someone stating, not getting invited to the pool party because of the commotion at the house or something. This statement caught the defendant off guard, as Captain Keller indicated during his interviews with Chandler police just after the incident occurred that he only saw the male outside on the curb and did not mention even seeing this defendant. During closing arguments while addressing the justification defenses, Ms. Trina K told the jury that the defendant was not entitled to any of these self-defense instructions. Ms. Trina K also gave false statements by saying Alex had no reason to be at this defendant's home and that this defendant told Alex to bring a gun. Ms. Trina K knew from previous testimony, interviews, and pre-trial defense interviews that Summer had begged Alex to go over to the defendant's house because of Summer's concern for the defendant's safety. Well, why didn't you call Summer on the stand? Why didn't you call any witnesses, Lori? Finally, Ms. Trina K commented several times on this defendant's demeanor, the nonchalant enchilada, during this incident, drive to the police station on the body cam and told the jury, you did not see her cry in that interview. Yet, knowing there were portions of the defendant's interview that had been cut from the full interview admitted by the state where she sat in the room and did show emotion and can be seen grabbing a Kleenex. Court's lack of impartiality. The court precluded this defendant from presenting a defense by striking her witnesses, including but not limited to Nate Eaton. Again, Nate Eaton, the news reporter, and Brandon Boudreaux before they were even called to stand. I could have sworn that the judge said that he was going to preclude them, but then I could have sworn the judge said he might have allowed to, he was open to maybe allowing her to call them or something like that. From what I've remembered, it wasn't like a complete shutdown. It was like, okay, well, maybe they can testify if X, Y, and Z or something. And then maybe Lori ended up not calling them. Specifically, before testimony began, the court requires the defendant to establish on the record, the relevancy. Okay, the relevancy. Yeah, she has an issue with the R word. What relevancy her witnesses represent. Damn, I think that triggers her. Relevancy. This requires the defendant to state in front of the prosecutor her defense strategy. This is not required under the law or any rule of evidence. They just wanted to know why they were relevant. And she's like, well, I can't tell you why they're relevant without, showing what my strategy is going to be. It's like, okay. During cross-examination of civilian witnesses, Serena Sharp, in relation to the testimony regarding religious beliefs, the court commented, beliefs? The court commented during the prosecutor's objection to relevancy, stating, I guess to the extent that you're comparing yourself to these biblical figures, I will allow it. Oh, yes, I remember the judge making that comment. Part of the state's case was to establish the defendant has stepped outside of the Mormon religion by claiming she was a translated being, specifically in text messages saying that she would be like Nephi, and that these messages were nothing more than the part of the conspiracy to kill Charles Vallow. I mean, when the judge made that statement, I didn't hear her make an objection or saying something like that. She didn't say nothing. Oh boy. This defendant attempted to establish that being translated was a regular part of the Mormon religion and thus a relevant line of questioning. Argument and authority. All right. We're almost halfway there. Arizona rules of criminal procedure provide that a court may grant a new trial when jurors and jurors have committed misconduct by receiving evidence not properly admitted during trial. But here's the thing. I don't think that the juror was Googling this when he wasn't supposed to. I think it was after he was released. You know how the judge is like, okay, thank you for your service. You have now been released, blah, 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 blah. You can do your whatever. I could have sworn that's when the juror did the what's it called? The Google of Lori Vallow. The defendant's entitled to a new trial because the jury received and consulted extraneous evidence. I don't think he did. Preclusion of Tylee and Alex Cox's statements because the court allowed expert testimony without a Rule 702 ruling this defendant is entitled to a new trial. A new trial is appropriate if, for any other reason, not due to the defendant's own fault, the defendant has not received a fair and partial trial. By precluding Tylee and Alex Cox's statement, this defendant was prevented from presenting part of her defense at trial and thus did not receive a fair and impartial trial. Okay, we're just repeating here. The court made a pretrial ruling that at least to Alex Cox's statements, it would make a statement by statement ruling. Instead, this defendant was precluded from even discussing Alex Cox's statement during his walkthrough. These walkthrough statements form the basis of Detective Coons being able to testify as an expert, yet she was precluded from cross-examination him on this foundation. For this basis, the defendant is entitled to a new trial. I'm trying to remember what the defendant mentioned about Alex Cox in the walkthrough. Or not the defendant, the detective. I think it's the defendant. I think I remember him talking about the walkthrough, or like Alex told him what happened or something like that. I don't know. Discovery violation occurred in the middle of the trial, entitled the defendant to a new trial. Discovery rules are designed to implement and not impede the fair and speedy trial rights. On April 14, 2025, during trial, Ms. Trina K produced a hard drive containing the gray key information for Charles Vallow's cell phone. I don't know. I read this article where it basically summarized Trina K's response, and I could have sworn the article said that she had the documents for maybe over a year, or she's had the documents for a while, the defense did, and just I don't know, maybe didn't do anything with it or didn't know how to open it or didn't engage with it until middle of trial or something like that. The state's discovery violation is important. One, the importance of the evidence, which the defendant was deprived during cross-examination, the right to confrontation and proper investigation and examination for the defense. And I don't know. Well, honestly, I'm going to get to the state's response because I don't know if I could really believe Lori Vallow that midway, Ms. K was like, oops, here you go. I forgot about this. Here you go. Take it. All right, prosecutor misconduct entitles the defendant for a new trial. Let's see. New trial is appropriate if for any other reason not due to the defendant's own fault, the defendant has not received a fair and impartial trial. This includes prosecutor misconduct. The statement elicited from Captain Keller was irrelevant and prejudicial to this defendant, yet Trina K purposely asked his witness if he overheard any statements. Well, I don't remember hearing her objecting. I wonder if the counsels that she has that are the advisory counsels, can they not help her along the way? Like, can they not chime in, or do they have to wait for Lori Vallow to ask them questions for them to assist? Because I feel like she was not really getting the assistance along the way unless she was asking. There was like a lot of times where there were no objections and Trina K got to do whatever the fuck she wanted because Lori just didn't really know what she was doing. Like we had like a lot of hearsay statements coming in, and Lori didn't object to it, especially when Kay Woodcock was testifying. Second, it is improper for the prosecutor to misstate the law or evidence during closing arguments. Ms. Trina K stated the defendant was not entitled to self-defense instructions, yet they were clearly provided to the jury. Ms. Trina K also gave false statements in her closing arguments by stating Alex had no reason to be at the defendant's home and that the defendant told him to bring a gun and extra ammo. Ms. Trina K knew from previous testimony interviews, pre-trial defense interviews, that Summer had begged Alex to go over the defendant's home because Summer's concerns were the defendant's safety. Maybe she just didn't believe it. Lastly, commenting on the defendant's demeanor, specifically stating the defendant did not cry during her police interview, was an improper comment as she had to cut this portion out of the exhibit, admitting that she called a full interview. Did Lori Vallow object at all during Trina K's closing arguments? Maybe she did. I don't remember. This part I think is kind of funny. Okay, the judge commenting on evidence. I mean, I don't know if he was I don't think he was commenting on evidence, but he was like sort of commenting on the testimony a little bit. By saying that Lori Vallow was trying to compare herself to these exalted beings or something like that. Okay. Court commented while responding to the state's relevant objection that the comment showed a specific claim of partiality by casting doubt on the defendant's credibility on this religious issue and in general showed she cannot be trusted. The court commenting to the relevancy objection, I guess to the extent you're comparing yourself to these biblical figures, I will allow it, can be seen as injecting his own opinion to the defendant's reliability during cross-examination. Yeah, and he did say it in a way that was very dismissive too. This comment is even more important when taken into consideration that Juror 15 in the Fox News 10 clip indicated he ultimately made a decision to vote guilty based on 2 text messages, including the one describing, I will be like Nephi. The court inserted his own improper comment when a simple overruled or sustained was warranted. This in of itself shows a lack of impartiality and requires a new trial. Respectfully submitted by Lori Daybell. We're going to read the state's response. I'm going to use the restroom. Hey, Shoobies, how are you doing today? Hello, Hippo. Hello, hello. How are you doing today? The juror can't literally say I misspoke because I was tired. Melanie Gibb, I believe, was part of the cult, but not the niece. Melanie. Really? I thought the niece was not part of it. I thought both Melanies were part of it. Okay. I could be wrong on that. Lori, knowing Lori's just probably like, I know what I'm doing. I know. She's got that self-confidence. Oof. That cockiness. I'll be right back. Use the bathroom and give me a second. Hey, what's up, Go Lucky? How are you doing today? She was the one who was commenting on everyone's testimony. The prosecutor had literally called it out. Yeah, she's projecting, maybe. Projecting. Waiting in your semi-truck near the airport, waiting your, fiance's plane to land. Where is she coming from? Oh, you guys run a disaster relief missions? Oh, that's awesome. She's been spending time with the family for a while. Hi, Go Lucky. How are you? Let me know if you see a gray cat in your area. My mom lost her gray cat. I was trying to help her out on Mother's Day. So if you're ever in the Silver Spring area, let me know if you see a gray cat. She was the one who was commenting. Oh, I read that already. Okay. All right. So let's hop on over to the state's response. We have 2 documents for the state's response. And I don't know why we have it in this font. What is this font here? Nick, thank you so much. Nick C, thank you so much for the the little lemon super chat. Looks like the lemon dude from Adventure Time. The unhinged lemon dude. That guy's wild. All right, state's response to the defendant's motion for a new trial. And then we also have a state's response for the defendant's motion to dismiss for abuse of discretion by the judge. Oh man, let's get into maybe the we'll do it by date. Okay. State of Arizona through undersigned counsel. Rick, why is the page all funky like this? Wait. Oh no, what's the format of this? Why is it like this? Hold on a second. How do I do continuous scrolling page view? Give me a second. It's gonna go black for a second. Combine pages, organize pages. How do I go to view pages? Add content, combine, convert, e-sign, new. No. For some reason, it's not scrolling continuously. It's like doing page breaks. I don't like that. I Anyone here a Adobe Acrobat nerd? Let's see. Adobe Acrobat, how to page view scroll. Click on the menu, preferences, accessibility. I don't see that. Menu? Menu. No. Menu? Menu, preferences, accessibility, page layout style. Single page continuous. I think that's what I want. Why is it not working? Page layout. Well, while we are waiting, what you guys eat for lunch today? Or dinner or breakfast, depending on what time it is over there. Oh no, my lunch is coming. I'm getting hungry soon. Override page display. Page layout. If anyone prefers to scroll. Me. I prefer to scroll. How do I do scroll? You prefer to scroll. Page display. Well, maybe it's not accessibility then. Page display. Automatic. It's not here. I think I would just have to have it zoom out for you guys. You would love Thai right now? Like Thai food? Oh, I actually made some Thai food. It was the first time I made it because it was like $18 for the stir-fried noodle thing. And I was like, I'm pretty sure this is really easy to make. And it will be way cheaper too. Okay, for some reason, this document is just funky. I don't know. Sometimes PDF documents are weird like that. Boo. Boo. All right, PDF document. Darn you. What I'm gonna have to do is... Oh my goodness. I'm gonna have to zoom it up for you guys. And I'm so sorry. You're not gonna really be able to read along, I don't think. It's gonna be too small for you. But this is the only way I can get the document to be shown on the screen. Otherwise, you won't be able to see it. Oh, damn, this kind of sucks. Sorry, y'all. This is the best I can do. There you go. It might cut off a little bit. Oh boy, that's a really small font to be reading. Let me see if I can zoom it in a little bit. Let's see. Well, it's not that bad. Okay. Not too bad. Not too bad. Yeah, I made what's it called? It's like the clear noodles. You stir fry it with some chicken. I put some bell peppers in there. Eggy, you know, little spices in there to make it spicy. Yeah, it's pretty good. I think I'm gonna eat that for lunch actually. All right, y'all. So I got my PDF stuff figured out, and hopefully it will cut off a little bit, but you guys will see the majority of it. State's response for the defendant's motion for a new trial. The state of Arizona, through undersigned counsel, requests this court deny defendant's motion for a new trial as there was no juror misconduct, no prosecutorial misconduct, no improper exclusion of hearsay testimony, and no lack of impartiality by the court. The state's response is supported by the memorandum of facts and authority. All right, guys. Let's see what the state says. Submitted May 6th. Facts, law, and argument. A, there was no juror misconduct. After the verdict, the jurors were released from the admonition and had to face a mob of journalists questioning them as they waited for the bus to take them to their vehicles. Juror number 15 was one of the jurors who was caught by the media. Juror 15 made multiple statements that were recorded by multiple agencies. Videos on YouTube from Idaho News on Demand shows for the first contact by the media with Juror 15 as he was exiting the South Court building. In this video, there are multiple media agencies rushing up to Juror 15. It is clear from the fact that you see the media running up to the juror that this encounter with the media occurred before the video cited by the defense, which was conducted next to the street/bus stop. In the initial media contact, one of the media asked Juror 15 and another juror, were any of you folks aware that this woman had already been convicted of 3 homicides? Juror 15 responds, no, I did not. Juror 15 and another juror are then asked, there's a lot of backstory here, and this woman has already been convicted of 3 homicides that they obviously didn't want you folks to know about that. And nobody knew that during your deliberations. Is that correct? Both Juror 15 and other juror both say no. Juror 15 was very clear in this immediate contact with the media that he did not know about the defendant's prior criminal history prior to reaching a verdict. A few days after the verdict, Juror 15 participated in an hour-long interview with Lauren Mathias for her podcast, Hidden True Crime. In that interview, Juror 15 states that everyone was respectful of not telling him anything about the case while the trial was going on, and that if anyone would have, I would have put a hand. During this hour-long interview, Juror 15 stated that after the verdict was read, they were released from the admonition. He started Googling Lori Vallow while still in the jury room. During the interview, from 15:30 minutes to 15:40 minutes, Juror 15 is asked in response, Lauren, is the day of the verdict you learn? It's the day of the verdict you learn, so is that what you quickly Googled on your phone and you saw that before you walked out of the courtroom? Juror 15, yeah. Lauren Mathias, that there were other murders. Juror 15, absolutely. Lauren Mathias, so you learned right then. Juror 15, uh-huh. During the interview, Juror 15 talks about not wanting to talk to the media when he left, but then all of a sudden he was surrounded. Juror 15 was asked directly by Mathias about whether or not he knew about other murders prior to the verdict. Lauren Mathias, but to clarify, you don't know how you might knew that there might have been another sentencing. Everything's a blur. I do understand that. Sometimes I forget what day, it is when I'm in attending trial, reporting at the trial. But you did not know about any of the murders until after the verdict? Juror 15. Right. Yeah, I had no idea of anything else she had been through prior to this trial, and even during the trial, I didn't know that. During this hour-long interview, Juror 15 repeatedly stated that he did not know about the defendant's prior murders or sentences before the verdict in this case. I just don't understand why the defense would just misrepresent this so horribly. I wonder if it was brought to Lori Vallow's attention and then she was fighting hard with the advisory council to include it in the motion. Because I don't know. I don't think Lori wrote that motion. During this hour-long interview, Juror 15 repeatedly stated that he did not know about the defendant's prior murders or sentences before the verdict in this case. No, I don't know who Alana Albert is. Do I know Alana Albert had passed away, Sarah Boone's friend? No idea. I really hope Lori gets Sarah Boone for her new Lori. Just saying. They would deserve each other, wouldn't they? Janie, who is that? Juror 15 spoke with multiple media outlets who accosted him as he was attempting to get to the juror, but I don't know about accosted. That sounds like too strong of a word. Accosted, I think of it starts getting a little bit physical. Accosted, I guess, to approach and address someone boldly or aggressively. Huh, I thought accosted had a physical element to it. I guess not. Okay, maybe not too strong then. The defendant is, because he was accosted by the media as he was trying to get on the juror bus. The video is provided by the state in Exhibit A, listed Idaho News on Demand. It's the first contact by the media with Juror 15, where he clearly states twice he did not know the defendant had been convicted of 3 other murders prior to the verdict. The defendant is later interviewed for an hour on the Hidden True Crime podcast, where he advised that as soon as he was released from the defendant, you mean the juror. The juror is later interviewed for an hour on the Hidden True Crime podcast, where he advised that as soon as he was released from the admonition, and while he was still in the jury room, he was Googling the defendant. I actually, you know what? Hold on. I do remember when the juror did make a statement saying that they Googled and found out that she was involved. I guess maybe they weren't super clear about that, because I think when I heard that, I was also saying oh, that's weird. I wonder if they did it afterwards. So maybe they weren't clear about that. But I mean, Lori Vallow would have had the Hidden True Crime podcast, and then also all the other footages by the time she filed for her motion for a new trial. So she would have had way more information, and it seems like she was still misrepresenting it. Juror 15 advised Mathias that this is when he learned she had prior convictions. When the juror again was asked if he didn't know about the information until after the verdict, he again confirmed he didn't know anything about this before or during the trial. The juror was basically mobbed by the media while trying to get the juror bus. During this time, Juror 15 made one sentence that seemed to imply he had looked up information about the defendant's prior criminal history before reaching a verdict. Looking at all the Juror 15's interaction with the media, it is clear he has remained consistent that he did not violate the admonition. He waited until he was released from the admonition to immediately begin Googling the defendant, that he and other jurors did not know about the defendant's prior convictions before reaching a verdict. So again, like what I was saying earlier, I think when we initially watched the interview, we were like, oh, that's kind of weird. But then by the time Lori Vallow made her motion, she would have already had more information than we did. All right, Tylee and Alex Cox being precluded as hearsay statements. In this case, the state appropriately filed motions in limine to preclude the defendant from admitting any statements made by Alexander Cox or Tylee Ryan, as these statements are hearsay and there is no exception that permits their admission. The court precluded the statements made by Tylee, made almost 3 hours after the shooting, as hearsay. The court also precluded any statements by Alexander Cox to the police from both when the police arrived 47 minutes after the shooting, as well as the statements he made at the police station a couple hours after the murder. The state also objected to, and the court sustained as hearsay, any testimony regarding Alexander Cox's walkthrough with the police nearly 8 hours after the shooting. Detective Daniel Coons was noticed by the state as an expert witness who discussed the trajectory of the shots of the crime scene, at the crime scene. During his testimony, the state asked Detective Daniel Coons if, based upon his training, experience, location of the casings, projectiles, bullet strikes, and injuries to Charles Vallow, if he can determine an approximate location of where the shooter would have been standing when 2 shots were fired. Detective Daniel Coons then provided his opinion that the shooter would have been standing in the air between the curved wall, hallway, and the kitchen. The defendant never established a foundation that any statements made by Alex Cox or Tylee Ryan hours after the shooting were admissible under any Arizona rules of evidence. Yep, that's pretty common with Lori Vallow. It's just like, oh, I just wanted in because I wanted in. The testimony of Alex Cox and Tylee Ryan were appropriately precluded as hearsay. During his testimony, Detective Daniel Coons gave his opinions as to the approximate location of the shooter based upon his training, experience, and the physical evidence to include the location of the casing, projectiles, bullet strikes, the location of the injuries to Charles Vallow, the wound path, trajectory through Charles Vallow. Detective Daniel Coons did not indicate that his opinion was based on the statements or walkthrough of the defendant's co-conspirator. That was what I was asking you guys earlier. I wasn't sure if you mentioned the walkthrough with Alex Cox or not. C, there was no discovery violation. Oh, okay, here's where we learn a little bit more. On January 9, 2024, the state disclosed the Celebrate phone download for Charles Vallow's iPhone to the defendant. Wow, so about a year ago. On January 13, 2024, the state filed state's notice of disclosure and request for disclosure. The notice advised the defendant that the state would use any evidence arising out of Chandler Police Department report DR 201-983-774, any information relevant to the case obtained from Celebrate downloads, and that all requests to examine or scientifically test items of the evidence must be in writing. So this is Lori Vallow's fault. Oh boy. On March 12, 2025, defendant filed a supplemental rule 15.2 notice of disclosure where she noticed an expert, Lonnie Dworkin. Yeah, they didn't even testify. Defendant never provided the state any notice regarding Dworkin's testimony because she doesn't know what she's doing. On March 13, 2025, the state was advised that Dworkin had not begun work. Oh boy, similar to this other expert that Lori Vallow wants to come in, the ballistics expert, for this other trial. On March 16, 2025, the state filed the state's motion to preclude a defense expert, Lonnie Dworkin, and preclude notice witnesses. The state filed a separate statement in support of Rule 15.7 sanctions due to the late and incomplete notice of defense expert, Lonnie Dworkin. On March 18, 2025, the defendant was asked by the court about Lonnie Dworkin. Yep, I think this is where we didn't hear about this, but we heard it later on when the trial actually started. Because I remember hearing the name Lonnie Dworkin. The defendant was advised that she could request a continuance to allow time for her expert to review the victim's cell phone. The court further advised the defendant that anything the expert discovered could potentially be precluded. The defendant advised she wanted to proceed with trial instead of seeking a continuance to allow her expert time to review the victim's cell phone. Oh my God, this is all Lori Vallow's doing. The defendant advised that she would like her expert to review Charles Vallow's actual cell phone. This is the first time the defendant requested access of the item of evidence. On March 18, 2025, the state emailed a stipulation to the defendant's investigator regarding the release of Charles Vallow's cell phone to defense expert Lonnie Dworkin to allow the expert to extract the cell phone. Jury selection for trial began on March 31st, 2025. The cell phone was returned to the Chandler Police Department on April 3rd, 2025. On April 7, 2025, while the state and defendant were presenting evidence and testimony in trial, the defendant emailed a motion to dismiss for failure to disclose exculpatory evidence and prosecutor misconduct. The motion provided no facts to support that any exculpatory evidence existed, nor did it provide any facts to support prosecutor misconduct. Wow. It's just because she says so. I don't need to provide any facts. I say so. What I say goes. Oh boy. Attached to the motion was an affidavit from defense expert Lonnie Dworkin requesting the raw data from the gray key extraction of, among items, Charles Vallow's cell phone. The defense expert did not advise that exculpatory evidence existed. It only provided that newer version of Cellbrite might be able to locate additional data that was unable to locate in 2019 and 2020 versions of Cellbrite. Oh man, now we're starting to get more understanding of some of the outside the jury presence arguments, because there are times where they're arguing things and we didn't really get a clear or a whole picture of what was going on, but now we know. I remember the judge mentioning that about the Cellbrite versions and how is it the state's fault that they didn't use the Cellbrite, the most up to date that they didn't use the newest Cellbrite version. Sorry, how was it the state's fault if they used the Cellbrite version that was available to them at that time? Yes, there's been new ones that came out after the fact, but they weren't available when the state did their examination of the phone. Okay, so they didn't. Again, Lori Vallow says there was exculpatory evidence on this phone, but then she didn't say what they were. Typical, classic Lori. On April 10, 2025, the state provided defendant with a thumb drive containing the gray key raw data of Charles Vallow's cell phone, iPad, MacBook to give to their defense expert. And this is what we saw during trial, where the defense was having issues with opening this thumb drive stuff. And it's so funny how Lori Vallow is like, well, even though I've had this for a year and I just hired an expert and the expert wants this information and now the state is giving it to me, it's prosecutorial misconduct. Because the prosecutor gave it to you when you asked for it, even though you're kind of sitting on it for a whole year. I mean, the judge even gave her, like, hey, do you want to have a continuation for this trial? And then she was like, no. Lori, what are you doing here? The state has not received any reports, notes, affidavits, or information relating to Lonnie Dworkin's review of the extraction of Charles Vallow's cell phone or his analysis of the gray key raw data. Something tells me Lori Vallow is just wasting money. She's probably had, this extra was probably paid to work on this case very late to try to extract the information. And then she ended up not even calling him. She had probably ended up not even using this information at all. Like, is she just like throwing money away? Does she not have to go through, you know how in Florida with Sarah Boone's trial, you have to have what's JCA? What's it called again? It was J something. Basically, anything that the defense wants to do, if the state's going to be paying for it, JCA has to approve it. Like, I don't know, is there anything like that in Arizona where they have to approve, like, Lori Vallow spending this, state's money to do this kind of shit? The state has not received any information advising that any exculpatory evidence was withheld from the defendant. Instead, the defendant's motion for a new trial makes an exclusion without any support that the gray key raw data contains exculpatory evidence. Yeah, because she doesn't know what the fuck she's talking about. She's just, like, throwing shit at the wall. In this case, the defendant did not provide the state in writing to request to examine the gray key raw data from the extraction of Charles Vallow's cell phone until April 7, 2025. Again, she's had it for over a year. Upon this request, the state provided this data. Furthermore, the defendant was not provided any documentation to support the claim that the gray key raw data included any exculpatory information that was not part of the Cellbrite data that was disclosed to the defendant on January 9, 2024. Defendant's motion does not support a Brady violation or any violation of disclosure by the state. Do you think Lori Vallow is even reading any of these responses? D, there's no prosecutorial misconduct. On April 8, 2025, the state elicited from the retired captain Kent Keller a statement made by the defendant while she was standing across the street from her rental house approximately an hour after her brother shot and killed her husband. The statement made by the defendant was admissible under 801D2 as a statement by a party opponent. Furthermore, the statement was relevant to show the defendant's demeanor during the investigation to the shooting of her husband. Yeah, Lori Vallow was very triggered if you called her nonchalant during those hours after the shooting. On April 21st, 2025, the court read the final jury instructions to the jury. The jury was advised. In their opening statements, the prosecutor and defendant talked to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you understand the law and the evidence. Take a sip of water. Lana passed in her sleep. She came to understand who Sarah is prior to her death. What do you mean she came to understand who Sarah Boone is prior to her death? Were they like pen pals or something? Jeep Wrangler was what Alex allegedly drove when shooting Brandon. Hey, Mari, how are you doing today? Thank you so much. During closing arguments on April 21st, 2025, the state made an argument to the jury about 3 of the justification defenses: self-defense, defense of a third party, and crime prevention. The defendant has intentionally mischaracterized one sentence from the state's closing to claim prosecutorial misconduct. The state provided both facts and evidence to support why the defendant was not entitled to self-defense, defense of a third party, and crime prevention. During closing arguments on April 21st, 2025, the state made an argument to the jury based on Exhibit 210, 227, Exhibit 222 that on July 9, 2019, Alex Cox made plans to have his brother Adam Cox stay with him on the night of July 10, 2019. Alex Cox's plans later changed on the night of July 9, 2019, when the defendant requested her co-conspirator Alex Cox to stay close to her the next couple of days. Again, Lori Vallow is trying to blame her sister. No, it was Summer. Summer was the one who begged Alex Cox to stay with Lori because she was so scared for Lori's well-being or some shit like that. The state's exhibits showed that Alex Cox did not answer his brother Adam Cox's calls or texts at 3:22 p.m. and on 3:23 on July 10, 2019. Can you guys hear that when I crack my neck? Although the state did interview the defendant's sister, she told the state detective Duncan that she spoke with Alex Cox the night of July 10, 2019 and begged him to stay with the defendant. The state thereafter was able to infer that since Alex Cox did not respond to Adam Cox hours before the defendant's sister spoke with him, that his plans to stay with the defendant were based on the discussions with the defendant on July 9, 2019. During closing argument, the state made argument to the jury regarding the defendant's demeanor from the time she arrived at the scene, almost an hour after the shooting, through the time she handed over the cell phone to Detective Inklin around 3 p.m. on the day of the shooting. And also, the jury, they were able to see this with their own eyes on the body cam and on the interview. Witnesses described the defendant on July 11, 2019 as chatty, nonchalant, and unaffected by her brother allegedly being struck with a baseball bat, her husband lying dead in her house, and her children no longer having a father. The defendant's demeanor with law enforcement the day of the murder was in complete opposition to the defendant's demeanor, during opening statements when the defendant attempted to testify as the facts that were never brought in by the defendant during the trial and crying in front of the jury. Ooh, Lori, I hope she reads this. She's going to get so triggered. In quotes, the prosecutor is permitted to argue all reasonable inferences from the evidence, but cannot make insinuations that are not supported by evidence. Prosecutors are given wide latitude in presenting closing arguments to the jury. In determining whether an argument is misconduct, we consider 2 factors. 1, whether the prosecutor's statements called to the jury's attention matters it should not have been considered in reaching its decision. 2, the probability that the jurors were in fact influenced by the remarks. In this case, the state did not argue or raise any matters the jury should not have considered. Each of the inferences and arguments made by the state during its closing arguments were based upon the testimony of witnesses and evidence admitted at trial. Seems like Lori's enjoying her time in a prison. In trial, she gets to dress up, feel important, have some control. She knows with the families this is justice and closure, but for her, ... she don't give a fuck. It's really ceremonial because she's never getting out regardless. The court remained impartial before, during, and after the trial. Oh, okay, so this is a statement with the statement that the judge made, I guess. The state filed 3 separate motions to preclude the defendant's notice of 15.2 witnesses. After each motion filed by the state, the court heard arguments as to the late notice, lack of witnesses being made available to the state, and their relevance to the trial. The court did not preclude most of the witnesses, even after multiple requests by the state. Yeah, the judge was being pretty lenient with Lori Vallow, and I think even right now he's being lenient with Lori Vallow in terms of her trying to get this ballistics person in. He's like, okay, well, you're past the discovery deadline. I'll keep an open mind, but, most likely he'll probably be precluded, but we'll see. It seems like, if Lori Vallow was a, real attorney, or if she was the state, the judge would be like, no, you passed the deadline. One witness, the defendant noticed, Nate Eaton, is a reporter with no personal knowledge of the case. Mr. Eaton filed his own motion to be allowed to remain in the courtroom. Later, Mr. Eaton's attorney filed a motion with the court. The court heard the argument by Mr. Eaton's lawyer and the defendant. Mr. Eaton's lawyer argued to remove Mr. Eaton from the defendant's list of witnesses and to allow him to remain in the courtroom during the trial. During this argument, the court asked the defendant why she needed Mr. Eaton, a reporter, for trial. The defendant indicated that Mr. Eaton might be used to impeach a witness who testified. The court advised the defendant that she would impeach a witness with Mr. Eaton's recordings. The court also advised the defendant that if she felt Mr. Eaton became a necessary witness, he would reconsider his preclusion even if Mr. Eaton was in a courtroom during testimony. The defendant never requested to call Mr. Eaton to impeach any witness. Yeah, she didn't call anyone. The state also filed 2 motions seeking to remove Brandon Boudreaux from the defendant's list as he is listed as a victim in a different case. During trial, the parties interviewed Brandon Boudreaux. In this interview, Mr. Boudreaux advised he was not aware that Adams Cox was in town or that Charles and Adam were planning on an intervention. The defendant was unable, yet again, to provide any other basis for calling him as a witness. The court struck Brandon Boudreaux from the defendant's witness list without prejudice, again advising the defendant that should Mr. Boudreaux become relevant, then the court would be open to hearing her argument. The defendant did not request Brandon Boudreaux to testify. Jesus, she's just like a hyper, messy little, I don't know, I was gonna call her Chihuahua, but I love Chihuahuas. She's like a hyper little messy, I don't know, yappy dog that doesn't know what they're doing, just running in circles. On April 10, 2025, the defendant cross-examined Serena Sharp. The defendant asked of the witness if several named people in the Bible were translated. The state objected to this as relevant. The court allowed the defendant to continue questioning the witness about this area. The defendant never asked Serena Sharp or any of the 3 other witnesses who were the members of the Church of Jesus Christ of Latter-day Saints who testified during this trial if they thought it was a regular part of the Mormon religion for the current person to be a translated being. Instead, the defendant merely asked one witness if there were people in the Bible who have been translated. It is well established, however, that a trial judge is presumed to be free of bias and prejudice. To rebut this presumption, in a criminal case, a party must prove by preponderance of evidence the judge's bias or prejudice and must file a motion alleging specific grounds of impartiality. Here, the defendant admitted that the court overruled the state's objection, but argues that one comment by the judge during a true 2-week trial is somehow rise to the level of establishing by a preponderance of evidence that the judge was bias or prejudice. The defendant has not shown any level that she is denied a fair trial before an impartial judge. Conclusion. Motion for a new trial should be denied, since the evidence supports that Juror 15 did not know about the defendant's prior felony convictions before reaching a verdict. The court properly excluded the hearsay testimony of Alex Cox and Tylee Ryan. The state's expert witness Daniel Coons relied upon the physical evidence at the scene and the autopsy of Charles Vallow to reach his conclusion as to the trajectory and general location of the shooter. And there has been no discovery violation by the state and no prosecutor misconduct by the state, and there's no evidence the court was biased or prejudiced against the defendant. He probably shouldn't have made that statement, though, but I thought it was really funny, and I was there for it. All right, this one is a lot shorter. So this is, again, the state's response to the defendant's motion to dismiss for abuse of discretion by by the judge. And again, Lori Vallow tried to do the same thing today in a different trial. And things were getting a little bit crazy because Lori Vallow was just yapping and not letting the judge talk at all, and the judge was just fed up with it. All right, this was filed a couple days ago. State of Arizona, through undecided counsel, requests this court deny the defendant's motion to dismiss as there is no abuse of discretion by the judge in excluding time to schedule this trial, and the defendant has not established any prejudice. This is by Trina Kay as well. Facts. On April 17, 2025, the parties were in trial in CR blah, blah, blah before Judge Boreski. In trial in, which one is it? Is this case or is this a Brandon Boudreaux one? 001704. This is for Brandon. No, sorry. Wait a second. They mix the stuff together? Hmm. 001704. Maybe this one is for the Brandon Boudreaux one, or no. The parties were in trial for before Judge Boreski. Why is the number different? Well, let me just read it. On April 17, 2025, the parties were in trial in CR 2021-001742 before Judge Boreski. Trial in CR 2021-001742 concluded on April 22, 2025. On April 17, 2025, the court formally rescheduled trial for this case. Oh, is this the Did they mix the Brandon Boudreaux one in the? I feel like that wouldn't make sense if they were to mix the two stuff together. Where did I find this? During the hearing on April 17, 2025, the court advised the parties that he intended to schedule the FTMC for May 14, 2025. Oh, I guess it is for the Brandon Boudreaux one. The status conference on May 29, 2025, and to begin with jury selection on May 30th, 2025. The court asked the defendant if she objects to the trial beginning on May 30th, 2025, since her last day was May 11, 2025. The defendant objected to waiving time. The court put on the record the reasons for sitting trial on May 30th, 2025. The states included that the state had to schedule travel for multiple out-of-state witnesses, that the court was unavailable part of the week on May 19, 2025, and the court was not available May 27 or 28. The state previously advised the court and the defendant that the state was not available May 21st to 23rd. This means that the court and state are unavailable May 19 through May 28th. The court also put on the record that the prejudice to the defendant was minimal, given that she is serving multiple natural life sentences in district court for Freeman County, Idaho. Law and argument. Let's see. Standards used for federal constitution to determine whether a delay is sufficient to reverse a conviction are 1. Length of delay. 2. Reasons for the delay. 3. Defendant's assertion of the right. Oh, okay. So she's saying that because there was a delay, how long did she say the delay was? If I remember correctly, I think she said that it was, they were trying to argue that it was delayed by like 18 days or something. And because of the delay, she was prejudiced in some way. The least important factor is the length of the delay, and the most important, the prejudicial effect. The Arizona Supreme Court has held that a delay for 20 months. It's not so long as to be prejudicial per se. 20 months, holy shit. In this case, the defendant's trial will begin 18 days. I had the number right. 18 days after the defendant's last day of May 12, 2025. All but 4 of these days, the court and the state were not available. The reason for the delay was that the parties were still in trial when this matter was set for trial, and the state had to make travel arrangements for 5 of the state witnesses. And the court and the state were unavailable May 19 to the 28th. Arizona Supreme Court has held that the most important factor when determining if a case should be dismissed is the prejudice to the defendant. April 17, 2025. Hey, what's up, good guy? Hi, Sarah. How are you doing today? Hello, hello. Oh, shit. Go lucky. I didn't even see that. I don't even see the view button. Where's the view button at? Oh, view? Page display? Enable scrolling? Automatic scroll? Single page view? 2? What do I do? Enable scrolling. Oh my gosh. Go lucky. I wish I saw your message earlier. Thank you. Thank you. Okay. I'm going to remember that. View and page display. That's what I was looking for. Oh my God. We're back. Yay. We can scroll again. All right. So it's delayed 18 days, but state and the court were unavailable. They had to fly some witnesses out. Arizona Supreme Court has held that the most important factor when determining the case should be dismissed is the prejudice to the defendant. On April 17, 2025, the defendant did not argue that she be prejudiced when she orally objected to the trial being set past the last day. Defendant, her motion to dismiss, also did not provide any evidence or argument, per usual, of actual prejudice to her as a result of the trial starting on May 3, 2025. Applying the 4 factors of this case, the case should not be dismissed. The court scheduled the trial as quickly as possible given the need to obtain witnesses for a trial, and then the parties were not available for a couple of weeks in May. Additionally, the defendant did not suffer any prejudice. She was already serving a life sentence. The delay of 18 days will not impact her ability to call witnesses or impact the memory of any witnesses. Sorry, Lori. Sorry, Lori. You just can't. I don't know. You can't go up against Miss Trina K, man. No, a kidney infection. Oh, you're healing now? That's good to hear. That sounds horrible. I'm doing okay. We if you were not part of the stream earlier, I recommend either go back and watch the beginning of the stream or wait until the video comes out, because we covered Lori Vallow's hearing and she was so fucking uninterested. The judge was not having it. I think the judge was getting really fed up with her. He's been really hard, he's been trying really hard to be patient with her. But oh man, Lori. The world is just against her. All right, y'all. So that is it for today for the Lori Vallow cases, plural, yes. Lori Vallow's going to have her 3rd trial in beginning of June. They're going to do jury selection at the end of May. And we are waiting to see the judge's response for Lori Vallow's motion to, well, there's a motion to dismiss the judge for abuse of discretion by the judge. She's already said it verbally in court today, and the judge is like, I deny it. And then the other one is Lori's motion for a new trial for the Arizona case for the conspiracy to commit murder of Charles Vallow. So we had a Lori Vallow day today. And, you know, I'm going to be ending it here because I'm going to catch up with the Karen Reed stuff. And I do want to do a stream with, let's see, you got Lori Vallow stuff. I kind of want to read the stuff with the Lexi Treviso stuff, and I don't know. There's like so many things I want to read with you guys. I think I'm gonna I'm gonna work on this Koberger video. Have that out because there's a lot of updates with Brian Koberger, and we're learning a little more information about what they were investigating into Brian Koberger, what they may have potentially found, and what they plan to present in trial, and then also what the defense is planning on presenting for the trial for Brian Koberger as well. So, a lot of stuff happening, and yeah, I gotta go back and did anything happen in the Karen Reed stuff so far? Did you guys watch Karen Reed after the lunch break? Yes, more nonchalance. More nonchalance. Oh man. Oh wait. Oh cool. This pickleball racket is now available. Let me ask my friend how I can get a discount then. All right, y'all. I hope you guys have a good one. Take care. Thank you so much for joining us for today. We listened to the Lori Vallow hearing, and then we covered the motion filed by Lori Vallow, and then the responses by the state. So I will probably have this up in a separate video and chop it up for you guys. And other than that, thank you so much for hanging with us. I hope you guys have a good one. Good night. Take care. Go outside, get some breath of fresh air, and I will see you guys probably later this week. I hope you guys have a good one. Take care. Oh, and Sarah Boone Sidebar Part 3, I will be posting that. Okay, I completely forgot.